The December 18th, 2025 hearing for the Planning and Land Development Regulation Commission is now called to order. And if I could have you please silence any audible devices that you may have. And if you would please join me for the Pledge of Allegiance.
To the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Good morning. I would like to thank everyone for joining us this morning. And Ms. Grinning, could I please have a roll call?
Member Arison?
Present.
Member Craig? Member Shelley?
Here.
Member Costa?
Here.
Member Bush?
Here.
Member Sixma?
Here.
Chair Mills?
Here. Thank you, Ms. Grinning. Okay, we do have minutes from our November 20th, 2025 meeting. Any discussion of those minutes? If not, I'll take a motion.
I'll make a motion to approve as submitted.
I'll second it.
Okay, I got a motion to approve the minutes from November 20th, 2025 from Ms. Shelley and a second from Mr. Urson. Any discussion on the motion? Hearing none, all those in favor signify by saying aye.
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 Any opposed? Motion carries unanimously. If anyone would like to speak for or against any of the cases being heard today, if you could please fill out a form at the back of the dais and hand it to Ms. Grinning to my immediate left. And we will be limiting you to a 3-minute time limit. And after the comments have been heard, I will give the applicant an opportunity to address any concerns the speakers have and answer any questions the commissioners may have. And at this time, I'd like to turn it over to Mr. Soria for legal comments.
Thank you, Mr. Chair, and this is for members of the public and for the applicants, that decisions by this body on cases which rezone real property from one classification to another pursuant to the zoning ordinance are recommendations only to the county council and do not constitute a final hearing. New evidence may be introduced at the county council public hearing. Decisions on variances and special exceptions made by this body constitute final action, subject to an appeal to the county council. And what this means is that no new evidence may be presented at the time of the county council public hearing on the appeal. An aggrieved party that appeals such a decision is confined to the record made before this body. Hearings by this body on rezonings, special exceptions, and variances are quasi-judicial in nature, meaning that this body is acting more like a court and must take into account all oral, written, or demonstrative evidence presented. Their decisions on these cases must be based on competent substantial evidence in the record, and competent substantial evidence has been defined as that evidence a reasonable mind would accept to support a conclusion. Thank you, Mr. Chair.
Thank you, Mr. Soria. And while on legal comments, I'd like to ask the commission to disclose for the record any ex parte communications that you may have occurred before or during the public hearing at which a vote is to be taken on any quasi-judicial matter. And I'll start to my immediate right with Mr. Urson.
None.
I have none. None.
None.
None.
None.
And I have none. Okay. Mr. Shams, do we have any items that need to be continued or withdrawn?
No, sir.
Thank you, sir. All right, we do have some unfinished old business. We got 3 cases here. Ms. Shelley, could I get the first case read into the record, please?
Yes, sir. Case number V-25-060, variances to the accessory structure requirements on Resource Corridor RC zoned property.
Thank you, Ms. Shelley. Ms. Tucker, this one's yours.
Good morning, Commission members. So today we bring before you a variance. The applicant is seeking 5 after-the-fact variances for a 917 square foot elevated accessory structure with attached staircase to resolve an ongoing code violation since 2020 in the Resource Corridor zoned property. The property currently contains a 3,421 square foot single-family home that was built in 2004, and the current owners purchased the property in April 2015. The accessory structure that we're talking about today started construction September of 2020. The parcel is approximately 12.5 acres, and it does not meet the minimum 25 acre of the Resource Corridor zoning, but is a legal non-conforming lot that was vested through a 2001 lot line adjustment. The lot has unique dimensions as it widens to the north, narrowing to the southern waterfront, and is subject to a front yard, side yard, and waterfront yard requirements. Today, the five variances that we're requesting is for variance 1 is to reduce the western side yard from 50 feet to 3 feet for an after-the-fact accessory structure in the RC zoning classification. Variance 2 is to reduce the eastern side yard from 50 feet to 12 feet for an after-the-fact accessory structure in the RC zoning classification. Variance 3 is to reduce the eastern side yard from 50 feet to 11 feet for an after-the-fact accessory structure in the RC zoning classification. Variance 4 is to reduce the eastern side yard from 50 feet to 7.5 feet for the after-the-fact accessory structure stairwell in the RC zoning classification. And variance 5 is to reduce the southern front yard the southern waterfront yard setback from 75 feet to 0 feet for an after-the-fact accessory structure staircase in the RC zoning classification. This site does lie in our Norma Natural Resource Management Area and includes wetlands which do require a 50-foot upland buffer. A site visit was conducted on September 11th with zoning, building and code enforcement, and environmental. We went out, talked to the applicant about what needed to be done to bring the structure into compliance as far as the building and code side, and then the variances that they were going to be requesting today. On that site visit, I did not observe any other parcels along the waterfront that had structures this large or this close to the waterfront yard line. Staff does recommend denial for variances 1 through 5 as the variances failed to meet 4 of the 5 criteria for granting a variance. Should the PLDRC find that the applicant has submitted additional substantial evidence for approval, staff has recommended 3 conditions that can be found on page 5 of your report package. I'm available for any questions.
Thank you, Ms. Tucker. Mr. Costa, you had a question?
I do. Good morning.
Good morning, sir.
I just want to confirm something here. On page 2 of the report, first paragraph said construction of the accessory structure was around September of 2020. And then when I look at the application they submitted, they're saying that the existing structure has been there since 1960. And
So there was an original non-conforming structure that we found on aerial photos dating back prior to 2005. It looked like it had been destroyed. The aerial photos weren't that great of quality, but it did look like a dilapidated structure. Once the applicants purchased the property in 2015 and 2020, they then started to do construction to rebuild and expand on that existing non-structure.
so they expanded on the existing structure.
Correct, yes, sir.
All right. Thank you.
Ms. Bush?
So then I take it there was never a permit originally pulled for the structure?
No, ma'am, we couldn't find one.
Any other questions for staff? All right, hearing none, is the applicant present? Could I get your name and address for the record, sir?
My name is Mark Jones. My office is located in Lake Mary, Florida.
Okay, you've heard the staff report. Anything you'd like to add to it?
Yeah, very much so. I just want to put it in a little bit more context, and I appreciate you asking the question because you're spot on. This is a saga that's been going on for several years now. This is the first time I've been in front of this board because I've spent a lot of time in front of the Code Enforcement Board. This property was cited by Code Enforcement, and it's very important for you folks to consider this. We've been in front of the Code Enforcement Board, Scott's not here, 8, 9, maybe 10 times. No fine has been imposed to date because we have consistently moved the ball forward in getting this property into compliance. This is the last piece of the puzzle to get into compliance. We have building plans in that we can get a permit approved if we get the variance. And some of this report says, well, you can't get the variance because you didn't get the permit. Well, I'm like a cat chasing its tail. So we're here to get the variance, and I think staff is on board with this. That's why we're seeing the 3 conditions that are in this report. To put it in proper context, this building was constructed, we don't know. DEP did a report. He was previously cited by DEP in 2020. I have here the compliance letter with DEP. So as far as DEP is concerned, the structure that's there is compliant under their codes. That structure was built, we believe, in the 1960s. I think it was just an old fishing shack that was built there that guys went in, would stay there on the weekends and go fishing on the river. It was a functioning, usable structure when Mr. Negrich purchased the property in 2015. I have photo evidence of that. I believe it's in the code enforcement file. It may not be in this file, but I can submit these into the record that shows his family utilizing the structure on the river back in 2015, 2016. If you folks remember, 2017, Hurricane Irma came through. The structure was damaged in Hurricane Irma. Got some photographs of that too, where the roof caved in on the structure. It took Mr. Negrich a little bit of time to get together the money and plans to repair and refurbish the existing non-conforming use, and he went forward based on bad advice and a misunderstanding of hurricane repairs and the needs for permits. And when DEP came down on him and when code enforcement came down on him, he sought about correcting the problem. And we have worked pretty darn hard over the last 3 or 4 years now to get to the point where we are today. I think we've submitted, I wish Scott was here because Scott's been very helpful. He was at the last site inspection with us, and the head guy over there, and I think we've submitted 3 sets of building plans. Did Mr. Negrich expand the footprint? Yes. Acknowledged, it's in the reports. He has since paid significant amounts of money to have crews come out there and reduce the size of the structure back to the original footprint. The plans that have been submitted and are pending approval are within the original footprint of the pre-existing non-conforming use, a property right that this gentleman had. That structure was never abandoned. He consistently used it, and he's got an existing property right in that structure in that location. Are we trying to get it under code? Are we trying to get the variance so that going forward on record, if he goes to sell it to somebody else, it's completely legitimate parcel? That's what we're trying to do. So I understand why staff has denied this thing. We don't want to set a precedent for anybody else coming in here and doing this, but I believe, there's Scott, we have an agreement here that we should get these variances, that we are going to get this thing properly permitted, and the structure should maintain. It's a very nice structure compared to what was up there previously. None of his neighbors, we sent the notices out to none of the neighbors. Nobody has complained. In fact, a couple were going to try to be here today, but they couldn't make it. So I just want to address a couple of things to get this in the record in case this doesn't go the way I want to and we have to appeal this thing. The 5 criteria that staff is supposed to look at for approval. Pardon me, I'm blind as a bat. Let me get my glasses on here. The first one is with special conditions. In this report, staff continues to say that he built an unpermitted accessory structure. Well, it is our position, again, this was a pre-existing non-conforming use. And a property owner has the right to repair and refurbish a pre-existing non-conforming use. They cannot expand it, which he did, and he's cut back to the original place, but he has a right to maintain a structure like that. And is there special conditions? Well, yeah, there is nothing else like that. They purchased this property in 2015. This was their dream parcel. They searched all over Volusia County to find something that they could access and fully utilize the river. That structure was there on the property. It was one of the factors that they bought that place. And they use that thing. His children are homeschooled. So their recess every single day is to go on down to the river and splash around in the water. So it's a benefit to their lives. The next condition was, are there any special conditions or circumstances that do not result from the actions of the applicant? Well, Mr. Negrich did not pick the location of that structure. It had been there for many years. And this was strictly a repair of the existing structure. The next one was, would denial create an unnecessary or undue hardship on the applicant? Well, staff says no. Well, I mean, absolutely it would. The cost of that building, to have him tear it down, would be a pretty big hardship. Almost 3 years of time that I have worked on this thing. He has paid me to work on this thing. He has worked on this thing. 3 sets of building plan. He's got a lot of money into getting this thing into full compliance. So it would be an absolute hardship upon him for you folks to deny us right here at the goal line. Even if staff has suggested that he could have gone on a permit to do this stuff, we still would need the variance. So I'd still be back in front of you folks. So we've done everything we need to get to this point. It's time to punch it past the goal line. The last two ones, sections 4 and condition 4 and 5. Is this the minimum variance required? Staff acknowledges it. First sentence, the requested variances are the minimum variances. However, you could reduce the structure to make it a less of an impact. It can't be any less. It's been there for over 60 years. There's no change in circumstances. And the last one, and I think the most important one, staff agrees on. Staff says the variances are unlikely to be injurious to the area. We're not asking for anything different than it has always been there. The structure has always been there. So respectfully, I would ask this board to go ahead and approve this variances. Let us get this saga over with, get the property completely in compliance, and everybody moves on. Thank you.
Okay. Mr. Mark?
Yes, sir.
Mr. Jones, we do have a question for you. Mr. Costa had a question.
I do. I wouldn't see nothing better than to move you guys forward, but I have some questions.
Sure.
So let's start with the first one. You said that this is you keep calling it a repair to the existing structure. So what percentage of the original building is still in place?
I can't answer that question.
A repair indicates to me that you're repairing something that's there, and so at least 50%, if not 70% of it is still viable, and you're repairing what's there. That's what I'm trying to get to. Is it a totally repair, or was it a tear down and a rebuild from the ground up? That makes a big difference to us.
Our position is it was a repair of the existing structure. The photographs that I have show the walls. The walls were still up, and again, it was an old structure. So
Okay.
he repaired the hurricane damage and renovated the existing structure.
So in the process of the repair, he also expanded the size of the unit of the.
So thank you. An explanation of that: the building that has an interior was actually reduced in size from its original. The decking that surrounds it is what he expanded to make use of around the structure. That's what went outside the footprint, and that's what has been reduced to bring it back inside the footprint.
Okay.
He literally took almost 2 feet off of the west side of the structure, and the plans that have been submitted take almost 6 to 8 feet off of the back of the structure that he put on. And we haven't done anything yet because we were waiting to get the measurements for the variances, get approvals for the variance, and do one final work on the property and be done. So that's what we're waiting for as approval.
All right. That's what I need.
Mr.
Thank you.
Jones, those pictures that you have, if you could provide them to the clerk so we can put them in the record.
Sure.
Yeah. Ms. Bush, you had a question?
Yeah, I just wanted to know if you had any pictures of the building before you made modifications.
I asked Mr. Negrich to search. I have every picture that we have available from his cell phone.
Because I hopped on Google Earth just to look at some historical aerials just to see, right? I don't know if you have any of those to provide, but I'm looking at it. I'm looking at 2019, January 2019, and it looks like the roof is off the structure. Does that seem about right,
That would have been,
timeline-wise?
Hurricane Irma was in 2017, so yes, that sounds accurate.
Right. So it's hard to tell what the footprint is, obviously, without the roof. And again, I'm looking at an older aerial. Then when I get to 2021, it shows a structure with the roof.
Yeah.
Right? And then when I get to 2023, it shows that roof expanded significantly, and it shows the decking. So that's why I wanted to see the before and after pictures, just to see, you say you didn't tear it down, you have the original footprint in place. But to me, just a quick Google Earth search, it looks like that got expanded. So that's why I really want evidence to show that it didn't get expanded. What you really are asking is for a variance for an existing structure.
And all I can tell you is this, because I've gotten into protracted litigation regarding pictometry and what you view from Google Earth and property lines and the property appraisers' websites. Those property lines that you see on the websites, they're not accurate. What we do have with building is surveys.
I'm not looking at property lines. I'm looking at the roof. I'm looking at the outline of the structure.
I understand. All I can tell you is what's been submitted with building. It shows that the structure is in the footprint. Scott, do we agree on that the current plans that we've submitted are in the footprint?
I don't have that full knowledge well, for the record, Scott Ashley, zoning manager. I think what's being proposed in a new building permit is approximately similar to what the original outline of the building based on the historic photos from our pictometry and from the DEP that we received as part of the environmental review. The addition has been substantially the front deck and the side walkways and the rear deck area, according to the building plans that were submitted, but are waiting this variance to be implemented. The applicant is proposing to cut it down as close as possible from, again, we're looking at the measurements from aerials. We don't have actual plans, but it's similar once the additions have been removed.
So I think to answer your question, did he go outside? We don't deny that he did. What we have in building brings it back, but we have to get the variance to finish it off.
Okay.
May I approach?
Okay. Ms. Shelley, you had a question?
Yeah, I just, you said you've been working on this, I believe, 3 years?
I believe so. I think I got on board in 2021, I believe it is.
Okay. I guess kind of my question is that, well, I guess it's not a question, I guess it's a statement. I see so many times that people buy a piece of property, and I don't know what can be done about this, but there are existing buildings on the property. And so, and I would probably do the same thing back in the day, but they start doing things with those existing buildings without realizing that those existing buildings were never permitted, had never gone through the process itself. So that always catches, I don't know, I'm not saying that that's all on your side, but there has to be something, because we see similar cases like this quite a bit because, well, the building was already there. And then in my question, I guess, is then why 3 years ago did you not, in working in this, why didn't it just start coming to this board to begin with?
Yeah. So some of it was advice from staff to get the final building so we knew what we were doing before we went forward with the variance. Another variable is hurricanes. Hurricane Ian, everybody has to remember what St. Johns River looked like after Hurricane Ian. We couldn't access the structure for months. I mean, it was months that he wasn't able to use it either. We just couldn't get to it. So no work could be done, no survey could be done, no remediation work could be done. The environmental, frankly, this wasn't the only violation on the property. This was the one that brought it out. Code enforcement came out and they're like, ding, 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 ding. So we were working on a lot of things, and I think we're pretty much in compliance on most of the other issues. This is the last piece to the puzzle. So the conditions on site itself prevented us, it dragged this thing out a lot.
Okay, thank you.
Yep.
Okay. Any more questions for the applicant? All right, I do have a question here. Number one is the setbacks that you're requesting, that's to the original building footprint, correct?
Correct.
Okay. The other thing is, back when this building was originally built, was there a permit even required to build that kind of structure then?
Not that I'm aware of.
Okay.
The existing non-conforming use predates just about every zoning code there is.
Okay. All right. This question also is for Scott or Mr. Soria. The permitting, I do know that back, I think it was Irma, that a lot of the permitting was waived to get structures back in
The
because
permitting,
we got hit so hard.
I think we waived permitting fees. We did that for Ian and Nicole and Milton. So anyone who wants to come in and repair and reconstruct, we waive those building permit and application fees. You still need a building permit to do construction because that's a state requirement. We control the fees that we charge.
So it is feasible that Mr. Negro could have possibly got that information and felt that he didn't need the permit to put the roof and stuff back on the
I'm
building.
not a mind reader. I don't know.
Okay, well, I'm just saying that it's not far-fetched to think that there wasn't a lenience during then that you didn't require a permit. Yeah. Yeah, okay. That was my point. Okay. Do we have any public participation forms for this case?
No, sir.
Okay, thank you, sir.
Thank you, folks.
We're going to be closing the floor for public participation and open up for commission discussion. Normally, going back to your line of questioning, Mr. Costa, when you were talking about if it was damaged beyond a certain amount, normally that's put in place when they originally applied for a variance, and if there was more damage than, I think it's 50 or 75%, then they would have to come back and ask for a new variance. This is a non-conforming building that's been back there since the 60s, and we don't even know if it was required to have a permit when the structure was built. So I just want you to keep that in mind. And the other thing, too, is it's not far-fetched to think that Mr. Negrich assumed that he didn't have to have a permit after the hurricane to put the roof or stuff back on the structure. Yes, he probably helped it along a little bit, but just keep that in mind also when you're making your decisions on this.
If I may.
Yes, sir.
So I don't disagree with you. My question is, though, this is a variance now. We pass this variance, grant the variance. Hurricane Herbert comes through next year and wipes it out. It's held to the same standard with the 75% rebuild before they have to come back in. Is it 75 or 50%?
It depends upon whether or not this is in the coastal high hazard area. If it is, it's 50%. If it's not, it's 75%.
So if they have to repair more than that, it has to come back to get the variance reinstated?
Depends on if you put that as a condition. So if you put it as a condition that if the structure is demolished for more than 75%, then they have to meet the code, you can do that. Otherwise, the variance applies to this structure and it allows them to reconstruct the structure in the exact same location with the exact same setbacks, unless this commission puts in a condition that says if you reach that, I think it's 75%.
I don't need to make it more restrictive than we need to. I mean, if that's the way it's written right now.
What you're not, okay, so if you grant this variance, you are making it you are removing the non-conforming structure designation from this parcel.
Off that building, it's just the building.
Just the building.
Got it.
So they can reconstruct within the approved setbacks that you grant unless you put in a condition.
Got it. All right, perfect. Thank you.
Okay, anyone else for the discussion part? Ms. Craig.
I'm thinking about the fact that they were looking for a piece of property for a long time, and this was the only one they found where they could do what they wanted to do, which makes me think that there might have been an awareness of the permits that would be required. And in a location like this, I'm very concerned with precedent. And the fact that it was an existing building goes to their favor, definitely, but it had been basically abandoned for quite some time, so that's a concern for me. Because so much is after the fact, it's sort of hard to separate one concern from the other. And so it's something to consider.
Okay. Ms. Bush.
Thank you, Chairman. You did a fabulous job with the remake of the structure. From the photos, it looks beautiful. And as a kid, I would love to have that in my backyard to be able to play and jump off and just be able to enjoy the St. Johns River. I think it's a beautiful structure. My issue with it, and I don't have issue with what you did. I think that you did with the information that you had at the time, right? And now you're in this predicament, and you're asking for forgiveness for a structure that you thought you had the ability to use and to modify and to improve for your family's use. However, my struggle is with structures that really shouldn't have been in that place in the first place, right? We're in a time where we see a lot of unprecedented flooding, right? You just examined or explained to us how you didn't have access to the property or to that structure for what seemed like months, right, because of the hurricanes. We're finding, right, as a county, as cities, I'm a land planner by trade, we're finding that we're building in areas that we really shouldn't be building in anymore because of flooding, because of natural disasters, and because we're having to rebuild them over and over and over again. And we're having to find that those consequences are on all of us, right? Insurance property, or our insurance raises go up, or prices go up, and the like. So I know that this is not a structure that you live in, but I am concerned about what the future destruction of the structure looks like, what that literally happens downstream, no pun intended. And that's part of the reason why I'm going to have issues voting in favor for this, even as how beautiful the structure is and you brought the whole property up in compliance and you're doing everything per the law now. I just don't think that we should have ever allowed that structure to be there in the first place. And I, like I said, appreciate what you've done, but I still think that your family can enjoy the property and enjoy the river from the land and not necessarily needing a structure to support their the use of that property. So those are my comments. Thank you.
Okay. All right, any other comments? I'll go back to what I originally said. That structure's been there for a structure, now maybe not that particular one. It's within the same footprint for 65 years that we know of. And the impact that it has had in the last 65 years is not going to, I wouldn't think, change for the future. So I just want you to keep that in mind. It's not as if it was a totally new structure, bought the property, and want to try to utilize it. Ms. Shelley.
And I'm not trying to belabor the point, it's just a thought. Sorry. Is that even though it's there for X amount of years, one of the things, and this is not just about this particular case, but it's just once again, a general comment, because I can understand, I would probably have done the same thing, but people need to realize just because there's a structure on your property that you buy, no matter how long it's been there and it needs repair and you start doing something to it, you have to have permits for anything moving forward. So that's just a word of warning to anyone out there so that you don't have to come before us. Thank you.
Okay, any more discussion?
Prepared to make a motion, Chair.
Go ahead, Mr. Costa.
Case V-25-060, make a motion that we approve variances 1, 2, 3, 4, and 5 with the 3 staff recommended conditions.
Second.
Got a motion on the floor to approve variance V-25060, variances 1, variance 2, 3, 4, and 5 with the 3 staff conditions from Mr. Costa and a second from Ms. Shelley. Any discussion on the motion?
My comment on top of that is that, yes, the variance is basically to legitimize the original building footprint from the 60s, not the new structure, which has now been pared back to the 60s level.
Okay, any other comments? All those in favor signify by saying aye.
Aye.
Any opposed?
Aye.
Ms. Craig?
She was an aye.
Okay. So motion carries
Yeah.
They couldn't hear you.
5-1, correct?
2, 3, 4, 5,
If you're
7.
confused, you should do a roll,
Somebody's missing.
You want to do a roll call?
just to clarify.
Okay. Ms. Gruden, can I get a roll call on that?
Member Arison?
In favor.
Member Craig?
No.
Member Shelley?
Yes.
Member Costa?
Yes.
Member Bush?
No.
Member Sixma?
Yes.
Chair Mills?
Yes.
5-2.
Okay, motion carries 5-2. Okay, Ms. Shelley, could I get the next case, please?
Yes, sir. Case number V-25-067, variances to the minimum yard requirements on urban single-family residential R4 zoned property.
Thank you, Ms. Shelley. Ms. Tucker, this one's yours.
Good morning, members. For the record, Kelly Tucker, Planner 1. The applicant is seeking 2 variances for a single-family residential structure on an urban single-family residential R4 zone property. There is a slight correction to the staff report. On page 2, there is the zoning classification requirements. It states A4. The title is the only thing that is different. It should be R4. The measurements for front, side, rear, and waterfront are correct. The property does currently contain a 1,252 square foot single-family home that was built in 2003, which is currently non-conforming due to a 5-foot westward shift of the home from the originally approved site plan that was approved by county staff in 2003. The applicants did purchase a property in 2017. This is a corner lot with primary access from 13th Street and a secondary front yard from DeLand Avenue. So this lot would be subject to 2 front yards and 2 side yards. There was a lot combination in 2002 that combined platted lots 18 through 21 on Block 53 of the West Highland subdivision, which did create the current property and its current standing, and it is eligible for building permits. The applicant does seek 2 variances. The first one is to reduce the westward front yard setback from 25 feet to 19 feet for the urban single-family residential home as it stands. This variance would solidify that if something were to happen to the home, it could be rebuilt in its current footprint. And the last variance is for a 70 square foot garbage enclosure that which would reduce the front yard setback on the west side from 25 feet to 12 feet. Environmental permitting did review this project and had no objections, but did state that they would have to meet the land development regulations. Staff's recommendation is to deny variance 1 for the 25 feet to 12 foot reduction for the attached accessory structure, and staff does recommend approval for variance 2, which is to approve the reduction of the 25 foot setback to 19 feet. There are also 3 staff recommendations of approval if the PLDRC does find the applicant provides competent evidence for support of approval on page 6. I'm available if you have any questions.
Thank you, Ms. Tucker. Any questions for staff? Mr. Costa?
Yeah, this is, am I reading this correctly? This is just a trash enclosure?
Yes, sir.
70 square feet?
Yes, sir. They have wildlife in the area, so they wanted to build an enclosure to keep the wildlife out of the trash cans.
And so we're going through permits, variance for a trash enclosure?
Yes, sir.
And so if they went to Home Depot and bought a similar plastic, stick them up there, would they have to go through the same process again?
If it were detached from the house and under the 480 square feet and would meet the side or rear yard requirements, they would not have to go through these requirements.
All right. Okay, thank you.
Yes, sir.
And the reason for the continuance was just for advertising, correct?
Correct, yes, sir.
Okay. All right. We don't have any other questions for staff. Hearing none, is the applicant present?
Come on, applicant.
The applicant's not present. Okay.
I'd make a motion that we delay this one to the last, just to give them a chance to show up if they're not here.
Yeah, I'll second that.
Hold on. Mr. DeParadis, you can go up.
Oh, he is here.
Oh, okay.
All right.
My name is Mo Hood. I'm the builder.
If I could get your name and address for the record.
Yes, Maurice Hood, Houde. The address is 1028 South Beresford Road.
Okay. Go ahead, sir.
And I'm representing the De Pereira's family. And while we realize that there's no permit required for the actual shed under 480 square feet, they didn't want to use a temporary structure that would be unattached from the house. They wanted something that was going to blend in with the house. There's really no other areas within the home footprint because there's windows. It's not exactly sightly. And then the convenience for bringing the trash to and from is lessened by virtue of its distance. And while we realized we don't need a permit, we wanted to, I was told by county officials to go through the variance process as opposed to the vacation process. So that's why we're here trying to present this to you today.
Okay, thank you, Mr. Hood.
You're welcome.
Mr. Costa, wait
I
just
got a
moment.
question for you, sir. Come on back.
Come back. Mr. Costa, go ahead.
So this is a 70 square foot trash enclosure.
Mm-hmm.
How long have you been going through this process to get to this point today?
Quite a while.
Approximately 3 weeks, 3 months, 3 years?
Probably 3 months.
3 months
Yeah.
for a trash enclosure.
Yeah.
Okay.
I presented this to the owner, and they still wanted to go forward. So
Understood.
They
No.
felt- they
I'm
felt
trying to
that
get the
strongly.
timeline and what it takes to get to make
Because it's
it.
really, they do some parking there with their vehicles, and it's really the only spot they can do it, and they really don't want something that looks plastic in the yard. That's kind
So is this going to have? It's not going to be living quarters of any sort. It's
of
just
course not. No.
Okay, got it.
No, double doors with just everything locked up, so they don't have to keep cleaning up the mess.
Good. All right. Thank you.
You're welcome.
Okay, Ms. Grinnan, do we have any public participation forms for this case?
No, sir.
Okay, we're going to close the floor for public participation or open up for commission discussion or a motion.
I'll be glad to make a motion.
Go ahead, Ms. Shelley.
We approve case number V-25-067, subject to the 3 staff conditions.
I'll second that.
And that's 1 and 2, correct?
Yes, sir.
Okay. I got a motion on the floor to approve variance V-25-067, variance 1 and 2 from Ms. Shelley with the staff condition. Is there conditions on this?
Yes, there's 3.
Free.
3 staff conditions. And a second from Mr. Urson. Any discussion on the motion? All those in favor signify by saying aye.
Aye.
Any opposed? Motion carries unanimously.
Hopefully you have it built by Christmas.
Ms. Shelley, could I get the next case?
Yes, sir. Case number V-26-001, a variance to the accessory structure requirements on Stone Island Planned Unit Development, PUD, zoned property.
Thank you. Mr. Shams, I believe this is you.
All right, good morning. I'm Steve
morning.
Shams with Bush County Planning. So this application was previously heard at the November PLDRC hearing. It was continued for 30 days. In the interim, the applicant has revised the request to remove 1 variance. The variance to the side yard is now gone, and the proposed structure will meet the 10-foot setback. The applicant also revised the variance to the rear yard from 3 feet to 7.2 feet. The rear yard requirement is 30 feet. A letter of support from the most affected property owner to the north has been provided. The size of the structure has not changed and is still 984 square feet for the storage of his boats. The structure has been shifted closer to the home to better meet the requirements of the Stone Island PUD. Based on comments made by the adjacent property owner, and since the site is in a flood zone, the project was reviewed by development engineering. A drainage affidavit will need to be signed by the applicant at permitting. We've included this as a condition. This is a typical requirement for sites within a flood zone. Environmental permitting also reviewed the project and had no objection, as long as they meet the land development code. And the applicant provided additional documentation yesterday afternoon to provide additional details of the site. This has been provided to you on a new plan. According to the documents, there is a well pump structure on the western area of the site that prevents him from locating the structure in that location. However, there is no special condition to the site, and the structure can be reduced in size to meet the yard requirements. So therefore, staff recommends denial of the variances as 5 of 5 criteria are not met. If PLDRC finds evidence to approve, staff recommends 4 conditions. Now available for comment or question.
Thank you, Mr. Shams. Any questions for staff? Mr. Costa?
Yep, this is more of a housekeeping comment than a question. The 3 handouts that we got today, other than the one where it has the case number, can we get the case numbers at least handwritten on these so we know what they go to?
Sure,
so we're
of
not
course.
fiddling through, please,
Yes.
for the future. Short of that, he did, from the last meeting that we had, we heard this last month, so the changes that we discussed have been made?
Yes, sir.
Okay, thank you.
Okay. Is the applicant present? Good morning, sir. Can I get your name and address for the record?
Zachary Huffman, 524 Providence Boulevard, Deltona.
Okay, you've heard the staff report. Anything you'd like to add to that?
No, sir.
Okay. Any questions for the applicant?
Besides just the hardships, we've gone everywhere on the property, and this is the only place where the building would actually fit on the property and still look aesthetic or cosmetically good. My brother's here also. He'd like to say a couple words.
Yeah, and the other,
Can I get your name and address for the record?
Dane Huffman, Dane Huffman, my address or this address?
Your address too, yeah. Your address.
1425 Kettle Drum Road, Stone Island.
Okay. Well, after you're done here, if you just fill out a public participation form and hand it to Ms. Grinnan to my left, okay?
After you're done.
Yeah, go ahead.
After I'm done.
Go ahead.
Well, there's an existing driveway there also that's currently there, which we're trying to utilize that. And I guess that's kind of it. And if we push the building any forward, she can't use it. We won't be able to access the garage because of the access point of the garage.
All right, sir.
Thank
Do
you.
we have any public participation forms for this case?
Yes, sir.
Do you have a question?
A comment?
Yeah.
Ready?
Go ahead.
I'm just looking at my notes from the last meeting, so confirming that you removed the side yard setback, eliminated 2 variances, and that's going to satisfy your neighbor's concerns. So we have a letter of a recommendation of approval from one of your neighbors?
From the neighbor behind.
Okay, and so the neighbor that was in opposition is not here today?
Yeah, he's here.
Is he
Mr.
here?
Moran's
Okay, so
here.
he's speaking. Okay, all right, I'll wait for that then. Thank you.
Yeah. Okay. We'll give you a chance for rebuttal if we do have a public participation forum, and otherwise we'll close the floor. But I did tell Mr. Moran he didn't have to do it again. We got it. If he's not satisfied with removing that one variance, you might want to speak. You want to speak? Yes, I do. All right. If I could get you to come forward.
Thank
Go
you.
ahead and have a seat, sir.
Thank you.
Thank you. And if you would fill out a public participation form again.
I did
and
already.
Give it to Ms. Grinnan.
I already did that, yeah. Robert Moran, 1450 Shelmont Road.
Okay.
After reviewing Stephen's report, they did not meet the 5 criteria. The issue I have with the back is taking 23 feet of the back is going to expose 23 feet for me to view. I'm not trying to be a bad neighbor or be difficult. I just want to stay with the PUD rules. If you can just imagine, an average school bus is it's like putting 3 school buses side by side, and I'm going to be looking at that from now on. There's other places on the property, or they can make it smaller. And again, I'm not trying to be difficult. I'm just trying to stay within the rules of the setback. When I purchased my home there, that's one of the reasons I did that, is because to keep it more private. There's other structures out there of that size that are within the setbacks, and they don't encroach at all on the setbacks. If you drive around out there, you'll see large structures like that also. So, and after not meeting any of their criteria, I can't see how he should be able to take any of that 30 feet. So again, I'm not trying to be difficult or be a bad neighbor. I just don't want to have that visual that I'm going to have all the time. That's it. Thank you.
All right, thank you. Mr. Costa. I'm sorry. Okay, got it. Okay. Do we have any other public participation forms for this case?
No, sir.
Okay, we're going to close the floor for public participation, open it up for commission discussion. I will say this, Mr. Sawyer, correct me if I'm wrong. From a visual aspect, are we supposed to consider that?
You can consider its impact to the neighbors as part of the variance request. I mean, there is a setbacks for structures of a certain size. That kind of implies there's a massing consideration. You know, if this was a smaller structure, less than 480 square feet, it could be 5 feet from the property line, according to your rules. But it's it is a larger structure, and it should be further back unless they can demonstrate the need for a variance.
Okay. All right. Thank you, sir. Ms. Bush.
This is a question for staff. I'm not sure if I asked this the last time, so I apologize. But have any other variances been granted for structures, accessory structures like this within the rear yard setback?
In this area or in
Yeah.
general? Oh,
Yeah.
no.
No. Because I'm looking at the aerial, and I don't really see anything on the aerial that's within that 30-foot, the rear yard setback of any of the properties.
No, I
within-
did investigate it, and I didn't find anything in that regard.
Okay. Thank you.
You're welcome.
Okay. All right. Mr. Costa, you had a question?
Yeah, I'm looking at the notes from the last meeting, and I thought this would put it to bed. And I'm reading from the minutes here. It said that Hoffman indicated he would be willing to modify his request to comply with a 10-foot side yard setback and only seek a variance for the rear yard setback. And one of the questions that I asked is how could we get to a resolution here? And the 10-foot was the issue, not the 30-foot. And now that the 10-foot has been resolved, he's removed that, the 30-foot becomes the issue. So basically, nothing that he's got planned here would be acceptable to the neighbor, if I'm reading this correctly and listening to the testimony correctly.
I think you're correct in assuming that.
Okay. All right. Well.
Okay. All right. Any other comments, or I'll accept the motion.
Yeah, let's make a motion, get this thing rolling. Case V-26-001, I make a motion to approve variance 1 with the
4 conditions.
4 conditions, I believe. Yep, 1, 2, 3, 4 staff recommended conditions.
Second.
I've got a motion on the floor to approve variance V-26-001 with the 4 staff recommended conditions from Mr. Costa and a second from Ms. Shelley. Any discussion on the motion? All those, Ms. Bush.
I'm just concerned about setting a precedent in an area that has very strict setback design standards. Well, maybe not strict to today's standards, but they were designed themselves. And I, for the record, had concern over both setbacks the last time we discussed this, not just those side yards. So just wanted to make that a point for the record. Thank you.
Okay, Ms. Craig.
Thank you. My concern is that the neighbor has such an issue with it. I think that neighbors' rights are, as much as I would love for everybody to be able to develop their property however they want, if it is a problem for the neighbors and they've been there for a while, I really feel that that speaks very loudly. Thank you.
Ms. Shelley.
Yes, and I am really uncomfortable voting for something that fails to meet any of the criteria that we use for discussion and recommendations.
Okay. Mr. Urson.
I understand this is a PUD. Is this a homeowners association as well? There is no HOA? Okay. So I do concur with my colleagues. I'm also uncomfortable.
Okay. No, sir.
We're close, yeah.
We've closed the floor for public participation. Okay. All right. So we've got any more discussion on the motion? We have a motion on the floor. Did we get a second on it? Yes. Ms. Shelley, okay. Yeah, okay.
I have a procedural question. This gets shot down here. Can they appeal to the county, to the council?
Yes.
Very
Within 10 days of the rendition, they're confined to the record made today and from the previous hearing. They'll combine it all into, take both minutes and both evidence presented.
So they can appeal it to the council, and then council has the final say on it?
Yes.
Okay. Or they could withdraw and come back?
Sure, if you allow them to make that withdrawal, because they are here before you.
Sure.
This commission has the authority to accept the request for withdrawal.
Okay. All right. So before we take a vote, I just want to make that comment to the applicants that you have that option to withdraw your application right now and come back, regroup and come back, or if you read the room and this doesn't go your way, it goes to council, then you can appeal it to council, and that they would have the final say. So it's your call.
Let me clarify that. He's
Sure.
got the option to request the withdrawal.
To request the withdrawal, rather. Sorry. Yes.
Okay. Okay. Are you finished? Mr.
Yeah, I'm
Coates?
done. Thank
Okay.
you.
The only other thing that I could see here would be to maybe appease the neighbor would be for him to meet the 30-foot setback as to put it the opposite way behind the structure of the home. That'd be the other thing. I know there's what was that, a well inspection? Yeah. Was it a well or is it actual? I think
No, there's a shed.
Yeah. All right. Okay. Okay. In our discussion, I would like to ask our colleagues here if he were to do anything other than what is presented today, at any point would change your opinion on your decision? If so, by anyone, let me know.
Yes, I think I would be willing to vote for it if it met the setbacks.
If it met the setback, then they wouldn't need a revariance.
Good point. But I just have a problem with 7.2 feet. That just seems extremely close to the property line. So yes, if it were further in, I think I might be more inclined to vote for it.
Okay. Okay. Unfortunately, sir, we've closed the floor for public participation. Okay.
Chairman, to answer your question, I'll agree with Member Craig. If it's not a little bit more than 7.5 feet, I'm just worried about the precedent that we're setting about such a large accessory structure in such a small setback, or with a reduced setback. So I think if we can maybe match the side yard, or at least provide double digits there, at least showing intent to provide that distance between that rear neighbor and to provide that buffer and clarity for view for the potential side neighbor, I would be in favor of that. It's really the precedent and how large the structure is that I'm uncomfortable with.
Okay. Does that change anything for anyone? Okay. All right, we do have a motion on the floor from Mr. Costa and a second from Ms. Shelley. Any more discussion on the motion? All those in favor signify by saying aye.
Aye.
Any opposed?
Aye.
What do we have?
I was the only yes that I heard, so I was the lone yes, apparently.
And the reason I'm saying this is because he can appeal it to the council. Yeah. We've heard it
I think
twice.
we need a roll call.
Do we need a roll call?
So that was the question failed. We like doing things here in the affirmative. So if you would, I would request the motion to deny the variance from any of the members, so we can have an affirmative vote for them to appeal to council.
Okay.
So moved. I'll do that.
Okay. Go ahead, Mr. Urson, make your motion.
You have to make it. Yeah.
I think you made a motion to deny.
Motion to deny, yes.
I'll second.
I got a motion to deny from Mr. Urson and a second from Ms. Bush. Any discussion on the motion? All those in favor signify by saying aye.
Aye.
Any opposed?
Aye.
Motion carries
6-1.
6-1.
Oh, motion, yeah, fails, carries, however you want.
Yeah. Well, that motion.
6-1 to deny.
Okay, that takes care of our unfinished old business, so we'll move right into our new business. Ms. Shelley, can I get our first case, please?
Yes. Case number V-26-004, variance to the accessory structure setback requirements on urban single-family residential R4 zoned property.
Thank you, Ms. Shelley. This is Mr. Jaskula.
Correct.
There you are.
Yeah. Joseph Jaskula, Planner 2, for the record. Good morning. Before I start, there have been 2 letters of opposition that got submitted recently, so I'm making that first. The applicant is seeking 2 variances. Variance 1 is a setback from 5 feet to 1.8 feet for a 383 square foot accessory structure dog kennel. The second variance is a setback from 8 feet to 3.35 feet for a 763 square foot accessory structure barn. The subject property is located on the northeast corner of Reynolds Street and Central Avenue in De Leon Springs. This is an after-fact variance for a roughly 22,000 square foot parcel with a 1,500 square foot single-family residence with 2 accessory structures to the east of the principal structure. The barn was built prior to the applicant's occupancy with an expired permit in 1995 with unpermitted additions later on. However, the dog kennel was built in 2024 by the applicant. There's an active code enforcement case that prompted these variances that is related to the breeding and selling of dogs. The kennel itself is not permitted, which triggered the variances. Environmental permitting reviewed the variance request and stated that they have no objection as long as they comply with the environmental regulations of the Land Development Code. There was a letter of support, but they did not list what variances they were in support of, and the signatures were listed multiple times. Staff recommends denial for variance number 1, as the applicant fails to meet criteria 1, 2, 3, and 4. and staff recommends denial for variance 2 as the application fails to meet criteria 1, 3, and 4. Should PLDRC find the applicant has provided the competent substantial evidence for approval, the conditions are provided. Thank you.
Thank you, Mr. Cusa. Mr. Costa.
My question is regarding the kennel itself. Is that allowed by right on that property?
I think it's special exception.
It can be a special exception or a hobby breeder. Up until 5 dogs.
Yes.
Anything less than 5 dogs.
That's correct. As a single-family resident, you can have up to 5 animals on your own property.
Without any kind of exception or anything
That's
otherwise,
correct.
Because we don't have any, the variances here aren't for the kennel itself, it's for the location of the structure, correct?
Correct.
Right.
Not about the breeding of the dogs or the kennel
Well,
itself.
yeah, and the structure itself is a kennel for the personal dogs, my understanding.
Gotcha.
Yeah, the business part apparently
That's a whole
was-
different, but that's not part of this, that's not part of what we're looking at today. Today is just the structure location.
That's
It was
correct.
just stating the code enforcement as the precedence for the variance.
Okay. Is that, the reason I asked that is the 2 letters of disapproval, I guess, that you gave us this morning are both disapproving the kennel itself. Okay, got it. Thank you.
Okay. Any other questions for the staff?
Chair Mills, may I add that the applicant supplied 5 letters of support this morning?
5 letters of support?
Yes.
Yeah, okay. Yeah.
I will make a note. I reached out and told her about the letters of support not being valid enough, so she went and reached back out and got those letters of support. So,
Okay. All right. Ms. Bush, you had a question for staff?
Yeah, I'm just curious because I know that this all stemmed from a code enforcement issue, right? And the code enforcement issue obviously is, irrespective of what we're discussing here, but that brought up the issue of the wood barn not being permitted, correct?
correct.
We've had other cases brought before us, not through code enforcement, but through other accessory structures wanting to be constructed, that also had unpermitted structures that likely need a variance, right? I think it was like last month we saw a case like that. So why are we now looking at a case today that is seeking 2 variances, one for a structure that obviously she constructed, but one that she didn't, that's historical, when we're not following those same rules and procedures to other cases that have come before us? So can you tell me why this one's different?
It was a part of the request. Whenever it came in, we discussed it with the applicant at that time. And I believe that there's just been a change of how these reports have been written over the years. We used to identify every non-conforming structure and unpermitted structure on the property and let the applicants know and just automatically add them to the report. And then it has switched in the past few years to where we only looked at their request. We are trying to be more customer service oriented with the way that we write these reports and identify the structures that they do wish to maintain on the site and include them if that's what they want to do.
Okay, so this was the applicants requesting to
After we
bring
had
this into
discussions with them.
okay. Thank you. And for the record, that would be really great to be added into the staff report, because I was like, to me, reading this and looking at how we've historically looked at non-conforming structures that aren't necessarily a part of what we need to be reviewing, that hasn't been a part of the case, right? So I definitely want to see that moving forward, especially if that's going to be a change approved, which I appreciate, right? Thank you. But just make sure that that's in the record in the staff report.
Correct.
Thank you.
Yep.
Any other questions for staff? Is the applicant present? Thank you, Mr. Kusa. Can I get your name and address for the record, please?
Yes, I'm Marilyn Rose, and my address is 150 Shady Branch Trail.
Okay, you've heard the staff report. Anything you'd like to add to it?
Well, just that none of this was intended in malice. The barn, which is you just spoke of, was built in 20 years ago, and we had no idea that it was not in compliance. So when we built the dog kennel, She has 5 German Shepherds, which we didn't want running the yard. They were running the fence, chasing kids on bikes. And so, we didn't want to put them in small cages. We didn't think that would be humane. And so she built a kennel. And we built it in line with the barn, not knowing that the barn was out of compliance, trying to keep it aesthetically nice. We have taken the property from an old ran down, replaced all the wood in the home, wood on the barn, repainted it, really tried to bring the property up. And my thing was, whenever we wanted to build a kennel, that it was going to be a good thing for the neighborhood. It was going to be a good thing for the property. And I said, just make sure it is well built, looks nice, aesthetically in line, and keep everything good. I had no idea that the barn was out of compliance. So now we're looking at taking down a beautiful, well-built barn, a nice kennel that, provides safety for the neighbors. The dogs aren't vicious, but they're big dogs. And they're chasing kids on bicycles, which, has got to be scary. So for the neighborhood, we thought that it would be a very good thing to keep them restrained. She does let them out, 1 or 2 at a time when she is outside with them or either on the front porch watching them, so that they get a little bit of exercise. It's almost an acre there and they can kind of run it. There was something else I was going to say and I can't. And it's all over 3.2 feet. We're 3.2 feet too close to the property line. And so to take down a barn and to remove the kennel for 3.2 feet, it would be a big expense. It would leave an eyesore. It wouldn't look good. And we were trying to do something good.
Okay. Can you, are you a hobby breeder?
My daughter is a hobby breeder.
She's a licensed hobby breeder?
No, she has not gotten her license as yet. In fact, she ceased and she stopped breeding. She has stopped breeding for a little over a year and a half. I'm not sure. But because she was working with the SPCA and they gave her this whole line of stuff to do and she done it all. And then they said,
Ma'am, we're not going to have a conversation back and forth. You're more than welcome to come up and speak at the podium if you'd like, but we'll give you a public participation form for that. Go ahead.
But I didn't think it was over the breeding, but over the kennel itself to keep the dogs in safe.
Okay. How many dogs do you have there? 5. Okay.
There's 5 kennels and 5 dogs.
Okay.
Five separate kennels. Or they're together, but 5 enclosures.
Okay. So let me make this clear. This is a variance for the buildings, not the dogs, because she's allowed 5 dogs.
Yes.
Mr. Costa.
That's my next question. So you got 5 personal dogs.
Yes.
So let's say the kennel goes away, you're still going to have 5 personal dogs.
Yeah.
In the backyard. They're going to be in the backyard as opposed to the kennel.
Yeah, running the
The
yard.
difference is not, so you're not boarding dogs.
No.
These are your own private
no,
dogs.
No, not
Thank
boarding
you.
dogs.
Thank you.
All right. I'm going to have to ask you to keep the conversation down in the back, okay? All right. Anything else you'd like to say?
No, I don't think so.
Okay, we do have some public participation forms. I'll give you a chance for rebuttal after those spoken.
Okay.
And so if you just have a seat nearby, please.
Okay. All right. Thank
Okay.
you.
Mr. Clayton Bino.
Good
Morning,
morning.
sir. Could I get your name and address for the record?
Clayton Benio, 5040 Commerce Avenue, De Leon Springs.
All right. You've heard the applicant, and there was something you'd like to add to it. And could I get your name also? And
I'm Martin Padada. I'm his attorney, 120 East Rich Avenue, DeLand, Florida.
All right, sir. You've heard the comments that have been made, and you would like to make a comment to that.
Yes, I'd like Martin to speak for me because he knows a lot about this case.
No, you speak your mind.
Also, first and foremost, they are breeding animals on that property and right now selling those animals off of that property. She does not have a hobby breeder's license, and she's been doing this for 2 years, contrary to what was just spoken. I want that for the record. They have also jumped the fence, chased other animals, bitten 2 people. Use your imagination.
Okay.
I do have an advertisement to submit to support the position that she is running a breeding kennel?
Okay.
Doesn't have a license?
You can turn it in, you can use it as part of this, but for the record, we're actually looking at variance for the building structure itself. If there's any code violations as far as the breeding, that would have to be done through code enforcement. Okay, so basically what we're looking at today is the setbacks to the property line for the buildings.
Okay. Well, then I'd ask you to support what the recommendation is of the
staff report,
and that it should be denied for the reasons that he listed.
Okay. Thank you. All right. Any other comments you'd like to make, sir?
Yes. As far as it goes for the barn, the original builder of the barn is in the audience right here. The actual designer is sitting right over there, EPI. And yes, there were permits pulled and they were approved for the barn structure itself.
Okay.
Well, that's
all right. All right. Thank you. Thank you. Do we have any other public participation forums for this? Oh, Mr. Costa, did you have a question or a comment? Okay. All right. Ms. Brennan?
Yes, sir. There were 3 total.
There was 3 total. One was the applicant himself.
Okay. Then maybe there was one more.
I have.
Both of them.
I have Marilyn Rose, Clayton Bino, and Mr. Padati.
Okay, then that would be all. I'm sorry.
Yeah. Okay. Ms. Rose, would you like to rebuttal? All right. Okay, we're going to close the floor for public participation, open up for commission discussion.
Yeah. To the comment that was made about the barn being permitted. Where you at, Joe? There you go. Any research on that at all?
Yeah, so
to justify that?
We're looking in our database, and they were the permits were expired in 1995, and then other additions were made but not recorded. So it was a smaller structure, and then additions got put in.
So the 1995 permits were
for a smaller structure.
For a smaller structure. Yeah. So they would have needed the variances that we're looking at today for the existing.
Right? I believe the side yard would still need
the side yard, even though they were approved previously and expired. That's my question. Are we in between times here and setbacks, and changes in setbacks? That's my question, I guess.
I don't think it changed the setbacks.
Okay.
It was more of expansion outward. Rather than.
You follow what I'm asking, right?
Yes.
If it was permitted and approved, was it approved in the location that it's currently in? Was that setback not an issue back then?
I do not recall.
Okay. All right. Good. That's a good answer.
Yeah.
Okay. Okay.
Plausible deniability.
Okay. Any other discussion? I'm going to address the speaker's concerns about the breeding. That is definitely a code enforcement. That's not with this board at all. You bring it to their attention. If they're in violation, I'm sure it'd be addressed. It's not something we can consider as far as if it's what they're doing with the buildings, it's the buildings themselves. Okay? I just don't want you to get the wrong impression. We're saying, yeah, you can do whatever you want to as far as the breeding side goes, because that's not what we're here for. Okay, Mr. Costa.
Yeah, I want to add to that, and I'll go ahead and make a motion at the same time, is that, the variance is strictly for the kennel itself, to house the dogs. And whether the kennel exists or does not exist, the 5 dogs will continue to exist because they are allowed by right. All the other factors, I'll call it white noise because it doesn't belong to this panel. It belongs to the code enforcement panel. So that's where you need to go next with regarding the breeding of the dogs themselves. With that, I will make a motion on case V-26-004 that we approve variances 1 and 2 with the 4 staff recommended conditions.
I'll second that.
Okay. I got a motion on the floor to approve variance V26004, variance 1 and 2 with the 4 staff conditions. Any discussion on the motion? Ms. Craig?
I'd like to see the 2 variances separated for vote.
Okay. We can do that. Could we do that?
Hang on, let me look at the conditions.
Especially if it's a request from one of the members.
Sure. I'll amend my motion. Same motion, we're just going to break it up into 2 separate votes. Variance 1, make a motion V26004, the approved variance number 1 with the staff recommended conditions. And a second motion on the same case for variance number 2 that we approve with the staff recommended conditions. 2 votes.
Okay, we'll take a vote on variance 1 first. So, any discussion on that motion?
Variance 1 is the accessory structure for the dog kennel.
Correct.
Yep. Okay. Any discussion on that motion? Okay. All those in favor signify by saying aye.
Aye.
Any opposed? Aye.
No. Or aye.
Count them out.
All right, let's do a roll call.
Member Arison?
In favor.
Member Craig?
No.
Member Shelley?
No.
Member Costa?
Yes.
Member Bush?
Yes.
Member Sixma?
Yes.
Chair Mills?
No.
3-3. We missing one?
4-3.
4-3.
4-3 in favor. Okay.
Okay.
Now we'll take a vote on, any discussion on variance 2 with the conditions from staff. All those in favor signify by saying aye.
Aye.
Any opposed? Motion carries unanimously on that one.
So that's 4.
Okay.
Yeah, it was 4-3 on the pass. Okay.
That's-
But the variance 1 was 4-3 pass?
Yes.
So they both passed?
Yep.
Okay, thank you.
Okay. Okay, Ms. Shelley, could I get the next case, please?
Case number V-26-007, variances to the accessory structure requirements on urban single-family residential R3 zoned property.
Ms. Tucker?
Good morning. Again, for the record, Kelly Tucker, Planner 1. Today, the case I've brought before you, the applicants are seeking 2 variances for an after-the-fact 387 square foot accessory structure to resolve an ongoing code violation case. The site is currently developed with a 2,622 square foot single-family residence that was constructed in 1972, and the applicants purchased the property in August 2014. The site is subject to a front yard along the eastern property boundary, 2 side yards along the northern and the southern boundaries, and a waterfront yard to the west. And it does meet the requirements of the R3 zoning classification as far as setbacks. However, the lot size does not. The minimum lot size for R3 is 10,000 square feet with a minimum width of 85, and the parcel has a width of 126 feet and approximately, I apologize, these notes are incorrect. The lot does meet the R3 requirements. The vested status is currently undetermined at this time, but staff is currently under review to deem it a vested lot. The violation came from a building inspector that was at an adjacent parcel and noticed that there was a solar array in the front yard with no building permits. After speaking with the applicants, they stated that they hired a solar company to install the panels for a backup generator. They were under the impression that the solar company went through, applied for the permits. However, they did not. So now they have a different contractor that they're trying to go through the proper steps. During the zoning review, they found that the solar array is in the front yard setback. And it's also it is also an accessory structure that is located in the front yard setback as well. During a site visit on November 5th, 2025, county staff observed planted landscaping in the front yard that did help to screen the solar array, as well as a black wooden border that follows the perimeter of the footprint that screens the solar array from viewing from the street front as well. Development engineering team did review this and found that there were some landscapes that were planted in the 50-foot right-of-way along John Anderson Drive. However, since then, it has been confirmed from Nicholas Ellis, who is in our DE department, that has solidified that some of the planting has been removed and they are up to code, and the plantings do still provide the proper screening for the solar array. The request today is for 2 variances. Variance 1 is to reduce the western front yard from 30 feet to 5 feet for an after-the-fact accessory structure in the R3 zoning classification. And variance 2 is to allow the after-the-fact accessory structure to be located in the front yard setback. Staff does recommend approval for variances 1 and 2. However, we did provide 2 conditions for PLDRC's consideration that can be found on page 4 of your staff report. I'm available for any questions.
Thank you, Ms. Tucker. Ms. Bush.
Thank you, Chairman. I have a couple questions. All right. So, when reviewing your justification for the 5 criteria, I found that there was little inconsistencies that I really wanted to bring up. First, and this is for section 4. You say that there's a financial burden for the reason why the criteria was met, that they could because of the financial burden. And I'll make this statement. In other variance applications for like accessory structures and sheds and things, that was never a reason for approving or saying that criteria was met. That it was always that the applicant could move said structure, right? Financial burden was never one of those criteria. So I guess my question is, why are we saying that financial burden is criteria? Is there a threshold that you all are using to justify whether or not that meets that criteria or not?
So for my impression, there is not a financial number for the criteria. With this job scope, there were buried electrical lines. So when speaking to the applicants, the cost of the variance was far more or less significant than the cost of uprooting those electrical lines and trying to find another viable spot on the property.
No, understood, right? But
I'm just saying that was my justification for the criteria.
Right, but in other in other variances past, they've already done something that it would have made it financially burdensome to move that structure. So I'm just pointing that out, that there's been some inconsistencies when applying this criteria to variance structures across. So that's number 1. Number 2, harmony with surrounding properties. How many front yard variances have been issued in this community for solar arrays in the front yard?
So the solar arrays, based on the aerial photos that I viewed and observed, they were either waterfront yard or they were roof mounted. The applicants didn't have the option to do roof mounted because the structural integrity of the roof, since the house was built in 72, it would not support the weight of the solar array. So that's why they were told that it had to be located on as a ground mount solar array.
Okay.
But based on my review, I didn't see any variances that have been applied for.
Right. And I understand the justification, the reason for putting it on the ground. I'm not denying that. My point is that I do not feel that it meets that criteria of being harmonious with the surrounding properties, because if there weren't a fence there, or there weren't some of those things, you would be able to see that array, and that would not be. There are no other solar arrays in the front yards of people's lawns in this community that I can see, that you can see, that we are all aware of, right? So I don't really feel like that criteria has been met, and I don't feel like criteria 4 has been met either, meaning that it wouldn't necessarily pass muster, and you guys would then recommend denial for this variance. It's not going to change our opinions of whether or not we feel like this should be approved or not, right? Everybody's going to have their own opinion of that. I just feel like the justification for you approving this criteria was much different than what we've seen in the past on these types of cases, and I just want to make sure there's consistency moving forward.
Understood. Thank you for the comment.
You're welcome.
Mr. Costa.
Yeah, I'm actually I'm a little surprised that solar panels are considered an accessory structure, but that's being said. The company that installed this, so there was never a permit pulled for this whatsoever?
No, sir. And then the number for the company was disconnected a couple weeks after the job was done.
Imagine that. Okay. Well, that's it then. I've got nothing else to say.
Ms. Craig, you had a comment or a question?
Yes, I had this is in my neighborhood, so I had the opportunity to drive past it, and I have to say, from the road, you see absolutely nothing because the structure itself is, as you can see on page 13, it's lower than the top of the fence, and because it's painted black the way it is not visible from the road, basically. So from that standpoint, I have no objection to it at all. I am concerned about this company doing all this work without permits, but I think that needs to come up some other
Okay,
place.
thank you, Ms. Tucker. We'll get forward.
I would also like to add that a letter of support was submitted to our office on Monday, which was after our publishing date, but you should have received a copy of that this morning as well. Thank you.
Thank you. Okay, is the applicant present? Good morning. Could I get your name and addresses for the record, please?
Linda Wace, 2058 John Anderson Drive in Ormond Beach.
Okay, sir?
Eric Blauberg, 2058 John Anderson Drive, Ormond Beach.
All right. So you've heard the staff report. Anything you'd like to add to it?
Well, one thing about the location is important. With solar panels, you have to have sun. And the issue we ran into when looking at different spots was there's trees, and our neighbor that was building the house, we knew that the house was going in, and that also, the more you push the solar panels in, away from the highway, we were getting less and less sun, more and more trees that were creating shade. It would do you no good. And our goal here was to have a solar generator for when the power goes out. So that's why we put them where we put them.
All right. Do we have any, Mr. Costa, you had a question?
I do. I want to know who installed them.
We're not going to go there. He never finished it. It was a partial, and it was really a misunderstanding because we said he'd take care of everything, and we just thought everything meant a permit too.
So you won't share the name?
No, we will not. That's not really fair. Besides, we can't reach him anyway, so you can't either.
All right. Did you want to add something, sir?
No, not really. I think it's all out there now.
This has been a terrible experience.
We just want to be in compliance with everything.
Yeah.
So
okay.
So we are with G. Henry Solar now, who in fact we had to go back and make sure all the plans were where they needed to be. So he's submitted them, and we're hoping to get this done soon.
Okay.
Yeah.
All right. Any other questions for the applicant?
Is it functioning now?
Excuse me?
Is it functioning now?
for emergency use,
It can
it
function,
can be.
yes.
Yeah, but we're waiting on all this.
Yeah, we're waiting for the inspections now.
Okay, do we have, Ms. Grennan, do we have any public participation forms for this case?
No, sir.
Okay, we're going to close the floor for public participation, open up for commission discussion or motion. You'll have your answer here shortly.
Thank you.
Thank you.
One thing I was going to say about it is they did do a good job of the placement of it. Just looking at the pictures, they did. I mean, it's nice and it looks very aesthetically where it's at. So.
Yeah, G. Henry helped us with a lot of that.
Yeah,
it's important to us.
The job was not finished, so G. Henry really
Sorry you
made
have to
sure
go through that part of it.
finished
but-
properly. Yeah.
Yeah. I'm ready to make a motion here.
Go ahead, Mr. Sixman.
Thank you.
Yeah. Anybody else have any? Okay.
We'll discuss it.
Case B26007. Make a motion for approval with 2 staff recommendations, conditions.
Variances 1 and 2.
What's that?
1
yes,
and 2.
1 and 2.
Okay.
Yeah.
I'll second it.
Okay, I've got a motion on the floor for Mr. Sixma to approve variance V26007, variances 1 and 2 with the 2 staff recommended conditions, and a second for Mr. Urson. Any discussion on the motion? Ms. Bush?
I just want the record to reflect that my comments on the staff report were for consistency for staff writing purposes, not necessarily for what this case is. I do feel like it's appropriate for the request, so thank you.
Any other comments on the motion? All those in favor signify by saying aye.
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 Any opposed? Motion carries unanimously.
Big better contractors.
Ms. Shelley, could I get the next case, please?
Yes, sir. Case number V-26-012, a variance to separate non-conforming lots on prime agriculture A1 zoned property.
Thank you, Ms. Shelley. And Ms. Ray, this is you.
Good morning, Kristen Ray, Planning and Development Services. The applicant is requesting a variance to separate non-conforming lots, the subject parcel from the adjacent parcel to the east. The owner of the subject property applied for a building permit for a single-family residence, and upon review, it was identified that the property required a vested rights determination. The subject property is zoned prime agriculture A1, and there is a minimum lot size of the A1 zoning classification of 10 acres. The subject property is approximately 5 acres in size, making it non-conforming to the zoning classification. A non-conforming lot letter was provided and showed previous common ownership to the parcel to the east. According to section 72-2061, 2 or more contiguous lots are considered undivided if common ownership existed on the effective date of the zoning ordinance, and if all or part of the lots do not meet the requirements established for lot width or lot area. The exception being if the lands involved were lawfully created and is developed with a permanent dwelling unit. The subject property is not yet developed with a permanent dwelling unit, therefore a variance to separate is required. The property is within the Samsula local plan and is in harmony with the local plan's goal of maintaining the existing rural, agriculture, and natural values. Staff's recommendation is to approve the variance request with no conditions. I'm available for questions.
Thank you, Ms. Ray. Any questions for staff? Ms. Bush?
So to confirm, I know you're subdividing the property, but they want to build on the property to the east. Is that correct?
Can you put that? Thank you. The property to the west. What you'll see at the top, that is their proposed residence that has a building permit in-house currently.
Okay.
Okay, any other questions? Mr. Costa?
Yeah. How big is the subject property
5
prior to subdivision?
5 acres.
5 acres. So we're going to create 2.5 acre parcels.
No, they're both 5 acre
So
parcels.
it's 10 acres total.
No.
And we're separating the two, correct?
No, they're already separated. There are 2 separate lots currently, but because there was previous common ownership, it's classified as undivided. However, they are currently owned by 2 separate owners, and they're both 5 acre parcels.
Got it. All right. They're both 5 acres. So we're not.
Yes, sir.
All right. We're not creating.
It's not nothing smaller than 5
a 2.5
acres.
acre parcel on Pepper Lane.
Correct.
Thank you.
Okay, any other questions for staff? Hearing none, is the applicant present? Thank you, Ms. Ray.
Good morning. For
Can
the
I get your
record,
name and address? Yes.
Yep. For the record, Josh Wells, attorney for the applicant, or attorney for the owner. I'm sorry. 340 North Causeway, New Smyrna Beach. So as you can see in the staff report here, the reason for the variance application today is basically the property as it was originally subdivided into a 5 acre piece existed under some prior zoning regulations that did allow 5 acre parcels. Since the original plat that created the parcel in question here, which is only to the parcel to the west, that's the only one that we own. The modern A1 zoning regulation was put in place that requires 10 acre parcels. We did try the non-conforming lot letter route, but there was a common ownership that dated to about 2006 in this case. So we were not able to use the non-conforming lot letter to get around the minimum lot size requirement. So the only variance is the minimum lot size, and the reason we're separating it is because, the common owner was the property to the east back until about 2006. But that's it.
Okay. Any other questions for the applicant? Do we have any public participation forums?
No, sir.
All right, we're going to close the floor for public participation over commission discussion or motion.
I'll be glad to make a motion.
Go ahead.
I move that we approve case number V-26-012, a variance to separate non-conforming lots on prime agriculture A1 zoned property.
I'll second that.
Okay, I've got a motion on the floor to approve variance V-26012 from Ms. Shelley and a second from Mr. Urson. Any discussion on the motion? Ms. Bush.
Just a question for staff. Just how often we issue or receive requests for the minimum lot size variances, or a variance for the minimum lot size?
And previously, it used to be common. However, I believe it was in 2023 that around there, that we put the exception that it had to be lawfully created and had a permitted single-family residence on it. So the only reason why the variance is in front of you today is because it does not yet have that single family.
Okay.
Yes, ma'am.
Thank you.
You're welcome.
Okay, any other comments or questions for on the motion? All those in favor signify by saying aye.
Aye.
Any opposed? Motion carries unanimously. All right, Ms. Shelley, could I get the next case, please?
Yes, sir. Case number PUD-24-009, a major amendment to the St. Johns River RV Storage BPUD.
Thank you, Ms. Shelley. And this is Mr. Shams.
Hi, good morning again. Steve Shams with Planning and Development Services. Just want to highlight one correction that was made to the report after publishing. The address on the very first page was corrected. So the applicant seeks to expand the St. Johns River Storage Business PUD from 7.25 acres to the full 23.75 acre site. The site is divided by a wetland corridor into an eastern and western section. There is an existing RV and boat storage operation on the eastern half. The application would amend and restate the existing PUD and its two minor amendments into a new PUD. So this agreement would replace the existing agreement. The original BPUD was approved in 2018 with a final site plan in 2019, and which was also modified in 2020 to provide phasing. Phase 1 was completed in February 2020, but the development order expired in January 2021. In addition, the previous owner made unauthorized improvements, including 68 uncovered vehicle spaces and a stormwater pond, which were identified as violations in January 2023 during a subdivision application. The current proposal aims to bring existing improvements into compliance and develop the western half with new improvements, such as an 80,000 square foot two-story mini warehouse, a 14,000 square foot storage structure, 36 covered spaces, and 88 uncovered spaces. If approved by County Council, the applicant must file for a new final site plan modification within 6 months or face PUD violations. If denied, unauthorized improvements will receive a notice of violation. The applicant plans to subdivide the property and sell one side, with the subdivision line coinciding with the existing zoning boundary. The surrounding land uses include a residential community to the west called St. John's Gardens, commercial watercraft services to the east, approximately 68 acres of timberland to the north, and utility and undeveloped lands to the south. The site is located along State Road 44, which is a thoroughfare overlay zone corridor, requiring additional standards for setbacks, landscaping, signage, and lot coverage. This proposed project is meeting these requirements. The City of DeLand also reviewed the project and recommended adequate stormwater management and enhanced landscape buffers. The site receives potable water from the City of DeLand utilities and uses an on-site septic system for wastewater treatment. The project is consistent with the comprehensive plan and was also reviewed by traffic engineering. The site is expected to generate 62 daily trips, and our engineering staff expressed no concern. Overall, staff recommends forwarding to the County Council with a recommendation of approval. I'll avail for comment or question.
Thank you, Mr. Shams. Any question for staff? Hearing none, is the applicant present? Good morning, Mr. Woods.
Good morning. Happy holidays to all of you. It's good to see you all. For the record, Michael Woods with the law firm Cobb Cole, 231 North Woodland Boulevard here in DeLand. And I think I've got a PowerPoint presentation. Be very brief. Very happy to be here before you. This is, as I will show you, my first, this is what I click with, right? Okay. Every time I do it wrong. Wait. Did I turn it off? Sorry, guys. Hey, all right. I'm just becoming my dad in my old age. This has been a project that has been in the application process for a little while, and I just kind of want to touch base as to why that is. This is the applicant right now My client is bringing the current property into compliance as a modern, fixing up some of the issues that were kind of created by the previous owner. Nothing really detrimental to anybody, but absolutely kind of, I'll only say as a headache to try to clean up how we were going to go about this. And the time frame that we've taken, like in the last 18 months to 2 years, has been how do we go about this efficiently and make sure that we do everything once, right? And so you can see the aerial photo there showing the vacant property and the wetland area that kind of bifurcates the property there. Even that splitting of the property, we will be able to do that, and we have designed it so it can be split separately. But part of that is just for financing purposes to go get a loan on one portion without impacting the existing facility on the eastern side. And if you've driven by, you've probably seen the facility as it currently exists. A lot of this was just really being driven by wanting to have additional large vehicle parking, boats and RV storage, just the lack of availability, lack of, I don't know how many times you guys have had code enforcement issue. Well, you don't have code enforcement, but have heard that City DeLand ends up having of people parking their vehicles in the front yards, not allowed to. So coming through here. But the history of the project, as Stephen said, was a BPUD by the Clemens family initially. And that was for the entirety of the east side of the property. And about midway through the project, it stalled out. So it wasn't initially phased. They worked with staff. Staff worked very hard to kind of get them back into a new compliance when they couldn't build out fully. What you have of the primary structures, and I'll kind of show you what that is now, was what was approved, but they still had other site improvements, including asphalt in the back that people have been parking on. So when you get notified here about having to come back in, put in for phasing, the stuff that has been done prior to my client coming forward now was to try to true that up of basically the project stalling out mid-grade and that old property owner and the county trying to put everything back together. Client now then came in as that was going forward. We were one of the reasons asking for the subdivision and the possibility for the subdivision, and then that's what triggered kind of a review of the site plan, and ultimately at staff's request with the PUD, and we came in on the west side, let's bring it all together, let's do a unified thing and clean it up. So, but that's taken a little bit of time. Minor amendments, that's the timing on that. Again, staff was exceedingly helpful. The biggest challenges that we've had, one was kind of the timing and structuring, but really there, I want to point out to two major conditions that we have on the site: power lines and the wetlands. And that is really what's dictated everything that we've done thus far. As you can kind of see here, this is the sketch plan, concept plan that's in your staff report. That yellow line there is the power line easement. It's an older power line easement, and you might as well fight against God and mankind if you're trying to change the conditions of that. The green area is the delineated wetland area. That exercise had already been done through the first phase, but it was updated. Good news, all wetland avoidance with the project. We've got the necessary upland buffers and setbacks provided for. From the timeline standpoint, with that power line easement, there's that substation that's the commercial or industrial property directly south of us. Then it runs north and then cuts over to Grand Avenue. So it's a robust power line area. We went through every iteration we could with the power company of, well, what is the scope that we can work within that area? Is there vehicle parking? Is there anything else? I learned a lot about power line easements, even to the fact that there is a really good reason why they have parallel going through or perpendicular crossing instead of parallel. We learned about temperature of the power lines. We learned about sag and arcing. All that is to say, it was a really good idea to stay out of the power line easement. And so basically that western 100 feet of the property became a hands-off for us. The only other thing that kind of goes through there is a current and will remain a emergency access for the power company to access the property off of Paradise. Other than that, there's a non-vehicular access easement that's required along with the Paradise Avenue access point. Paradise Avenue itself is I believe, a substandard roadway for the county's designation, but there's no real available additional right-of-way there because right off of their existing asphalt is the swale system. So very early on in the process, we leave that alone, leave that be as is. Our reliance is solely on State Road 44 for our access. And again, we worked with, in addition to just the power line easement, they've got some pretty broad language as to what you can do even outside the power line easement and their ability to come in and cut down whatever they want to. the height is stuff outside. So what you have proposed is something we worked with very hard with the county staff as far as our landscaping buffering outside of the power line easement, some 100 and something feet away from the property line and the actual structures, because we then just have vehicular parking first and foremost in the site plan. We're very far removed from Paradise Avenue. Wetlands, again, really just good news for that is that we're complying and not impacting those. So combined, it's kind of narrowed what our project is. This just from a standpoint, because it's sometimes hard to see what's proposed in black and white. So I got to take my crayons out, which I really love to do. You can ask my staff, and it is crayons. Power line easements in yellow. Our blue area is in the southwest corner is our proposed stormwater pond. Obviously, that's going to meet stormwater requirements at construction. In the northeast corner, that was the existing stormwater pond that will be brought into compliance with the new site plan revision. Green is our wetland area. The dark purple off of 44, those are our 2 access points. We do have 2 access points for the property so that we don't have any cross access in between through the wetlands. Again, trying to avoid that at all costs. The other purple lines you can kind of see on both sides of the property is the uncovered surface parking. In that northeast corner, that is part of what is being brought into compliance with the existing construction having to be permitted after the fact and cleaned up. There was, in one of the iterations of the PD, some additional covered storage on that area in the northeast corner, but we've clarified that. So what you see there now is what will be coming forward. Then we have in the orange is canopy parking, so some covering for your boats. And then in the pink area on the eastern side are the existing structures that are already in place that are fully enclosed. And then on the western side is the enclosed structures that are as proposed. We can get into any other details or questions that you may have, but this, I will tell you that this has gone through a substantial amount of near site plan level review. Like we've already worked through issues with Shane Lanou for fire, for the vehicular movement in and around there, sprinklering. And really, I would just tell you this because I think Mr. Costa was kind of bringing up the timing and permitting and stuff like that. We went full tilt with this. I think the initial thought process would be, hey, can we just get some surface parking put in? What's the minimum requirement to do that? And it very quickly becomes, well, if you have to go through this full process and everything like that, which is good, that's why you have a fully developed project coming through here when it really the conversation from the client initially was, can we get some additional parking out there because I have need of that with what's on the eastern side. But it's obviously very close to the river, so it's a great location for these types of vehicles to be stored. And other than that, we accept staff's recommendation for approval. They've worked very hand in hand. We've had so many drafts go back and forth on the approval, and I appreciate Steve and some patience with me. He's caught me on a couple of errors that I had, and it was very appreciative. So happy to answer any questions you may have and appreciate your time today.
Thank you, Mr. Woods. Any questions for the applicant? Mr. Costa.
Yeah, so you called my name out, so I figured I might as well ask a question.
Sure.
I'm not sure what question I was going to ask you, but I mean, give me the answer anyways. Go ahead.
Yeah. It's interesting having a unique use like this. This is my soapbox kind of thing, and going through the PUD because it is a more lengthy process than going with straight zoning. But there isn't really a really good definition for us to be able to utilize this. But I think you also recognize there's some need, and you see other storage facilities kind of popping up. And some of, I claim responsibility for some of that because our subdivisions are being built and they don't have as much storage or, you don't have a backyard. What I don't claim responsibility for is a lot of people have a lot of toys now, and it's the vehicles and the storage. So having a nice place for it to be and safe and easy to access is pretty good.
Those two developments go hand in hand. My question is that you mentioned the power line easement. Is that FPL or is that Duke?
It is currently it's Duke, right? Yeah. We've gone through it dated back to the old Florida Power Corporation. And initially it was interesting. There was some language in there, and the reason why we even had conversation with them is it contemplated a boulevarding on the outside of the power line easement. At this point in time, they were just like, no.
So they wouldn't allow uncovered parking underneath the power lines?
Correct. Well,
that's I find that unusual. That's why.
Yeah. So the conversation and they were reasonable, right? vehicular movement, part of the issue is how do you get them there? So we couldn't have a vehicle drive north-south through there because as it runs parallel with the power lines, I understand there's some arcing charging kind of building up.
All right.
We did talk through about, okay, let's assume that the drive aisle is just outside it and you're just pulling in. Then they get into a little bit about the height, and those power lines are fairly tall. Then we start getting conversations about, well, we have to worry about the voltage load and the temperature because then that causes a sag. And it started, that's our biggest stretch of time where we lost time. And ultimately the client was like, can we just get this moving forward and not go pick a fight? So.
Well, I like to pick fights, but that's one I have
we did our level best to try to.
Yeah, I mean, my issue is you have the easement. They have the easement on your property.
Yeah.
But you're paying the taxes on that easement.
It's a functional. It's as close to fee simple as you can be. But at the end of the day, Mike worked very hard. I mean, it gives him some design challenges for Mr. Wotuniak to get going through. But as a result of all of that, we're pretty far along with site plans.
You got in everything you wanted to get on that site.
I think so. Yes.
Okay. All right. Thank you.
Any other questions for the applicant? Okay. Do we have any public participation forms for this case?
No, sir.
All right, we're going to close the floor for public participation and open it up for commission discussion or a motion.
I'll be glad to make a motion.
Oh, go ahead, Ms. Shelley.
That we approve case number PUD-24-009, forward that rezoning case number, rezoning application case number to the county council for final action with recommendation of approval.
I'll second that.
Yeah, I got a motion on the floor to forward the rezoning application case number PUD 24009 to the county council for final action with a recommendation of approval from Ms. Shelley and a second from Mr. Urson. Any discussion on the motion? Ms. Bush.
Not really a discussion on the motion. I apologize. I probably should have asked this earlier. This is more of a question for staff. There are some blue dotted lines on your current and proposed zoning classification maps, and I'm just curious what those mean because you do not provide a legend for it.
The blue lines that you are seeing, the dotted that are going across, that identifies the thoroughfare overlay zone that is there. What? That's going to be that main one that you're seeing.
So this isn't an overlay?
Yes, it's in the thoroughfare overlay zone. That was identified in the report.
Okay.
And in the PUD document.
Okay. That would just be really great to identify on the maps moving forward.
Yes, we will have the thoroughfare. We'll work with our mapping team.
Yeah. Thank you.
Okay. All right, any other discussion on the motion? All those in favor signify by saying aye.
Aye.
Any opposed? Motion carries unanimously. All right. Okay. That takes care of all of our new business. Do we have any other public items?
No, sir.
We've got folks in the audience. Is that what is going on? Okay. Are they just here? Okay.
We could probably have them come up during citizen comments if you like.
I'll give that in a moment.
Sure.
Okay. Do we have any other public items?
No, sir.
Do we have any staff items?
Yes.
We sure do. Okay. We sent out a memo to you all regarding the research you requested for potential increase or not of the stipend that you receive monthly. And I just wanted to kind of open it up for any comments or questions on that, or if you had direction that you would like staff to move in for it.
Basically, you just shut us down, didn't you? On that memo.
Just
You
provide
just slammed. You didn't shut us down. You slammed the door.
I tried to let you know last time.
Yeah, it wasn't a soft shoe either. It was like a hard kick to that door. But no, I get it.
Okay.
You know, it doesn't. If you don't ask, you can't get. That's how I look at it. No's never hurt me before. Just means I'm not trying hard enough.
Well, let me crack the door open a little bit. when you made your comparisons, we were looking at the cities, and I bring into the fact that the Volusia County is about 1,438 square miles. City of DeLand, I believe, was 17.8 square miles. So we're not really comparing apples to apples here, because we're not asking to be paid to be put on the PLDRC as much as we're asking to be reimbursed for our expenses that we incur on the PLDRC. And based and going back, and one of the things that you said here, you said the state of Florida and the federal government mileage reimbursement rates are 70 cents per mile.
That was research that was done by our PDS administrative staff.
Okay. So if we
Real quick, Chairman, there should be a correction
any
there, though.
calculation here, if we just go to half of the sites, I don't believe our stipend covers that amount. Okay. Like I said, we're not asking to be paid. I think it is a privilege to be on the board. So I'm not asking to be paid. I'll donate my time. But what I'm concerned with is when the cost factor gets in, you start having to spend a considerable amount of money on the expenses you incur to go to each site. Now, yes, we can do Google Earth. We can ask our other colleagues here that live in the neighborhood what they see. But my experience is getting out there and actually seeing, because there have been times that I look at the staff report, I perceive one thing, then when I get to the site, I see something else. So it's really a benefit to get to these sites. So when Mr. Costa asked for an increase, I believe it was very well deserved, to be honest with you. Because at this rate of back in 1987, when the $200 was put into effect, the rate of that today would be almost 3 times as much. I think it's $2.87, the value of $1 back then to what it is today. So I did my little research also. So, but I just want to make sure we're comparing. When we make comparisons to other planning boards, I don't know how we can consider the cities simply because their square miles is considerably less than Volusia County.
Yeah, and so I had the cities because I had a feeling that y'all would ask about the cities and what they did. But I did, at the bottom of that are the counties as well, our surrounding counties.
Yeah, I do see the counties. And, well, give you an example. Putnam County is $30 per visit. Their square mileage is 827 compared to our 1,438. So if you look at that, and if you do even per visit, and if we go to 10 visits, that's $300 right there, and traveling more than what we would if we were in Putnam County. Okay. When you had it, the only other county that I saw that was listed that was actually more than what it was Brevard County. Was that no response, or they don't have any stipend at all?
Oh, they don't have a stipend at all. It's completely voluntary board with no payments.
Okay. That was the only one that was that I could see, other than what you have listed here. But anyway, I'll put it out there. I'll let the board decide what they want to do. I mean, I've lived with it for quite a few years, so you will do whatever you wish to do. Ms. Bush.
Thank you, Chairman. I just wanted to point out for the record, I did respond to the Ms. Weston staff when they submitted this, and the staff said that the mileage rate was state, and it is not. The state is still 0.445. I did verify that. That's the county is 0.7, and the feds are 0.7. So again, depending on what rate they want to reimburse us at, we could be losing money, right? So just for the record, I just wanted that, because I did bring that up. I was like, well, show me where in the state that the statute that shows that it's 0.7, because the state hasn't come up to that yet. The second thing that I just want to say And for the record, so that you know where I'm at, I'm not obviously in this for the money. I don't think any of us are. I don't travel to these locations, and if I were, I would probably then seek reimbursement. I think that might be the best way. I think that was one suggestion that another board did. But that's just me, right? I'm one voice on this. I think let a sleeping dog lie.
Okay. Any other comments?
I'll make a comment. I've served on multiple boards. I was really shocked, actually, to actually get a stipend on this board. I served, and when you say cities, it depends on the person on the board. I was on the planning board in Daytona Beach and chaired that board through some tumultuous years. For 18 years, actually, not chairman all that time. But I traveled the county and other areas because of impacts and different things, and just on my own to see what was going on, and never received a stipend as well. So I understand what people are talking about, but at the same time, I would and others have served on this board longer, and maybe that's something to do with it too. But as I said, I also served on the cultural council for the county, traveled to sites all around the county to visit those sites, and never got a stipend, nor did I expect one. So when this even came up, and when I got my first one, I was like, well, that's nice, but I didn't really, I'm just kind of a volunteer at heart in many ways, and I'm not saying others aren't. I understand that. But anyway, I'm fairly neutral on it, actually, so that's kind of where I stand.
Ms. Craig?
Thank you, Chair. I also was somewhat surprised and pleased when I found out that there was a stipend involved, but I have to say that after the work that I've done on the board, and I feel like I'm more willing to go out and do site visits because there is this coverage, and it's sort of it's an incentive. I don't know if it's guilt or just a sense of duty or whatever, that I want the county to get their money's worth. But I'm also somewhat neutral in that it's been sort of a gift in a way. It was an unexpected gift. I like it being there, but if it doesn't increase, they'll be able to put dinner on the table. So I'm somewhat neutral.
Okay, Mr. Costa?
Yeah, it was here when I got here, the stipend. Remember, too, that this year the council has decided that we don't have enough on our plate and have pushed quite a few items back to us for approval as opposed to the dual. And I think that workload alone, and again, a lot of these sites, yes, you can go through here and never step foot on any of these locations. But there's quite a few of these, and I would say the majority, not the minority, that benefit from my putting eyes and feet on the dirt to understand what the situation is. You can't always glean it from pictures or from the write-ups that people submit. And I think that the stipend is not about, hey, we need a raise. It's about the cost of fuel, the cost of automobile traffic. You're talking about eliminating the packets in general. So if we're going to require to be printing these and running the paper there's a cost for a volunteer to have to come out of pocket. That's what changes the thing. If it's just going to a couple meetings and attending some, soirees, yeah, that's great, but I haven't been invited to any lately. So that being said, the cost continues to go up, and I'm one of those that I like to gamble, just roll the dice and see what happens. I mean, did they take it away from us? They take it away from us. Worst they can do. They being the council, that is.
Staff would love to have a motion from the board on whether you would like us to proceed with a discussion item at county council. And if the discussion item includes a specific amount, I know you guys have floated whatever the percentage would be today, which is around $600 some odd per board member per meeting. So that would be great. So I know exactly what to do moving forward.
Scott, you were around when they put this into effect, weren't you? 1987.
So it
You were?
predates him.
Year before. The reason I asked this is because I was wondering what they base it on back then.
Well, even with the stipend that they adopted when I got here, we also had a van, which was, as I was told, was to help take members around the sites if need be, occasionally. Passenger van, which
And
was never used
sunshine
that.
come involved.
Yeah,
So
I think the
that
sunshine
went
kind
out
of
the
nixed
window.
that. So I didn't mind. It was the only car that had a radio, so.
Yeah.
Well,
you.
I'm not ready to move on anything. Budget season's come and gone. They're not going to council's not going to consider this till the next budget season anyway. It's just going to be tabled. I think we should just table
These
it.
guys have got money in their reserve. Don't let them fool you.
We don't, in our planning and development services budget, we did look to see if we could accommodate anything, and we have no additional movement.
That's why we're lacking sugar in the coffee brew, huh?
Might be.
Oh. They're concerned about your health.
You know, like I said, I take it as a privilege to be on this board, and it's not going to make me feel different one way or the other. I do know that it's been brought up by different people, and evidently some of us have changed our minds there. So I don't know where you guys want to go with this. If you want to send it to the council for discussion, we can do that. If it's not going to do it any good at this time, we can do it right before budget season next year.
Our budget season, when we are modifying our budgets, begins really in January, and it full on begins in March. So that's when staff has to put in the request for that next budget year. I know that council doesn't see it until around September, but we are working pretty much January 1. I have draft forms that I've been given last week.
Do you foresee any more cuts coming our way? As far, I know the issue with the mailing and the printing, is that subsided now? Is that stabilized, or is that still a push to go pure paperless?
The county is always wanting to go paperless. However, I have not heard anything additional. We do have our Director of Growth and Resource Management, Ray Tyner, in the audience, who, if he does have additional information on that, could get up and let us know.
Okay.
I'd be more than happy if we took away the paper. I mean, I really appreciate the paper and going through it in the way I operate. It's
We
very
have it
helpful.
budgeted for the printing cost. So we have not been anticipating any modifications to our budget in the Planning and Development Services division for the printing cost.
Mr. Chair, I'd be okay tabling this till like the March timeframe, which is that's in the peak season of them putting the budget together.
Yep, I support that.
And put it in there and see what happens.
Well, what I would do is each one of you should have a relationship with the commissioner that appointed you. Maybe have a discussion and see what their point of view is on it before we cut our throats.
Yeah, see if we have any support.
I'll put it out there,
Well,
plain
before
and
that
simple.
happens, I'd have to resign. I'm not going there.
So
I love
I
this
think
board,
what
but-
you would like to do is pretty much table it now, and then we can bring it back at a future meeting if we wanted to move forward to council with their feelings on that. And I would highly recommend each one of us reaching out to our appointers and see what their feelings are on it. See what they think.
I think that's a great idea.
Okay. All right. So we'll leave that alone for right now.
Okay.
That's your direction.
We do have a few more.
Are we in consensus on that? Okay.
Yes.
All right.
Okay.
We don't need
All right.
to-
I will float it again to you all come at the beginning of March. Okay. Another announcement that we have is that Joseph Jaskula, he is back in the back. He has accepted the position as our CRS coordinator, our community rating system coordinator. As a planner too, he still stays in our activity, which is great. He'll still be coming here, especially for the time being as we do a transition. But I just wanted to let you guys know that. And then we also have another
Yeah, so recently we had a member leave the county, Courtney Harris. He accepted a position with the city of Kissimmee about 2 weeks ago. So we just wanted to acknowledge him and thank him for his hard work and the time he spent with us. Wish him well.
Okay.
So if you know of any planners, we have an ad open.
I got one right out here.
Experience? We'll take it.
If you do have any time you have any of that, please send it my way because I have obviously connections with
might
UCF
be
being a
looking-
professor. So can make sure that especially entry level positions, a lot of my students are looking for those. Graduation is happening both for the master's program and the undergrad program graduates in May. So any of those opportunities, please send my way.
Awesome. We will. And that's all I have. So happy holidays.
Okay, and I heard you say, are you the gentleman that took the place of Clay Urban? All right. It's a pleasure to meet you. Okay.
And he's going to stay in his seat. He's not coming to the microphone.
All right, any staff comments?
No further comments.
Okay. Commission comments? Go ahead, Ms. Craig.
I have a question that I assume goes to staff regarding code enforcement violations, since there were two that were brought to our attention. I'm most concerned with the contractor who operated stealing money basically from the customers, doing unpermitted work, and they were cited, or a violation of some sort was filed. And I wonder what kind of ramifications there are for somebody like that.
Sure. So we have what's called the CLCA. That's the Contractor Licensing and It's a contractor licensing board that has jurisdiction over the act of contracting for both licensed and unlicensed contractors. So it works a little bit similar to our code enforcement board, but it is solely dealing with the punishment for the act of unlicensed contracting. They also have within their jurisdiction dilapidated structures. They are the ones who actually condemn and demolish structures. So that's an entirely kind of separate board. They have the ability to fine individuals. They have the ability to recommend them for further action by the state. If they're a state licensed contractor, they can pull their licensing permits within Volusia County and prohibit that individual, if they are found in violation, from doing any work in Volusia County. But for acts like these, where it's kind of fly by night, it's kind of a local board, so they would have to refer that particular entity. Someone has to make a complaint, they refer them to the state contracting board, and they can refer them to the state attorney to press any kind of criminal charges available. But their jurisdiction is over the act of unlicensed contracting. They issue fines. If you are a licensed contractor and you misbehave, they have more jurisdiction over you. They can issue restitutions. They've got, because you are engaged in the business of contracting with the public, you've got a fiduciary responsibility to it. So depending upon what their license status is, it would go through the contractor licensing board, which is the CLCA.
Any other commission comments? Okay, I would like to wish everybody a Merry Christmas. Have a safe holiday. And so, do we have any press and citizen comments? Nobody out there. Okay, this meeting's adjourned.
Just wanted to come for the day.
Not like it's interesting or
Yeah. Depends on who you are,
Yeah,
right?
you're right, you're right, you're right.
I find this stuff interesting, but it's just, that's me.
It's a pleasure having you on the board.
Thank
A lot
you.
of knowledge.
Thank you. I appreciate that. I've been been learning a lot. So I appreciate the support.
They're doing good. They're growing fast. Oh my gosh. We got some more coming in a month or two. Merry Christmas to you.
Merry Christmas.
Merry Christmas.
Happy
Take care of
New
that little
Year.
one.
Yeah.
Merry Christmas. Yeah, bye.
I like your sweater.
I love your sweater, by the way. Administratively, yeah.
We always do blue, because when you make a copy, it's on green. So that way you know which the original is. I'm just saying that, that's what I do at my office. I don't know, all of a sudden it stood out to me, I'm not sure why. So he said his name.
That's a good word for it.
I'll make sure to do the rendition letter correct this time.
Thank you, Eagle.
Stormwater, I don't know if it's a for everything, or who has any what.